Yeah, come on up, folks. Great. Okay, good morning, everybody, and thank you all for coming. I want to thank my good friend and one of our great legal experts in the whole Senate, Senator Blumenthal, for coming as well. As you all know, next week, the Senate Judiciary Committee will begin its hearing on President Trump's nominee to the Supreme Court, Judge Neil Gorsuch. Judge Gorsuch may act like a neutral, calm judge, but his record and his career clearly show he harbors a right-wing, pro-corporate special interest agenda. He enacted it time and time again on the 10th Circuit, and if given the chance, I have no doubt he would do it again on the Supreme Court. He expresses a lot of empathy and sympathy for the less powerful, but when it comes time to rule, when the chips are down, far too often he sides with the powerful few over everyday Americans trying to just get a fair shake. We've seen this play out time and time again. Judge Gorsuch repeatedly sided with insurance companies that wanted to deny disability benefits to employees. In employment discrimination cases, Bloomberg found he sided with employers 60% of the time. In one of the few cases he sided with an employee, it was a Republican woman who alleged she was fired for being a conservative. He wrote an article in 2005 that securities class actions, a powerful instrument to hold Wall Street accountable for corporate wrongdoing, were just tools for plaintiff lawyers to get free rides to fast riches. That is what I hear from corporate elitist after corporate elitist. As a judge, Neil Gorsuch repeatedly sided with the powerful against the powerless. But we now know his ties to corporate interests run even deeper than just ruling on their cases in the courtroom. He didn't just share a courtroom with corporate interests. He sat at the defendant's table defending them as well. Just this morning, the New York Times reported on Judge Gorsuch's deep ties to secretive billionaire Philip Anschutz, one of the leading funders of the hard right in America. This is not somebody who's neutral or just the head of a big corporation. He has been funding and pushing hard right causes for more than for decades. Judge Gorsuch represented Anschutz in his companies. Anschutz's top lawyer lobbied for Gorsuch to get the spot on the Federal Court of Appeals. And Judge Gorsuch has been partners in an LLC with two of Anschutz's top advisors building a vacation home together. Anschutz donates to the far-right Federalist Society and Heritage Foundation. Surprise, surprise. The Federalist Society put him on his list when President Trump outsourced Supreme Court nominees to these hard-right organizations. A hard-right conservative billionaire groomed and nurtured Judge Gorsuch for the 10th Circuit and now the Supreme Court. That is a cause for alarm for every working-class American and should give senators pause about putting him on the highest court of the land. It's also another contradiction in President Trump. He campaigned and talks about helping average folks. His first nominee to the Supreme Court has an instinctive reaction to side with big special corporate interests over average folks. The contrast between Judge Gorsuch's persona and his record is reminiscent of a prior nominee, Chief Justice Roberts. I sat with him. It was the same thing. Very judicious, very calm, very careful in his interview. And of course, he told everyone he just called balls and strikes. When he got to the court, he became one of the most activist judges we have ever seen, overturning First Amendment precedent to create the Citizens United case, probably the worst case with the worst effect on average Americans in a century, since Lochner, almost a century. These ties that Judge Gorsuch has to a secretive billionaire and the right-wing causes he supports are very troubling. The fact that he is eerily reminiscent of Judge Roberts, one of the most active right-wing judges we have seen, means that Judge Gorsuch has a lot of questions to answer for. And when it comes to our experience with Judge Roberts, we will not be fooled again. I voted against him the first time, but he fooled a lot of people who now regret voting for him. As you'll hear today, Judge Gorsuch's record demonstrates he prefers CEOs over truck drivers, executives over employers, and corporations over consumers. When Judge Gorsuch goes before the Judiciary Committee next week, he'll have to answer for his decisions. Not his empathetic words, but the decisions he wrote that favored the powerful over the powerless. Here with us today are people with personal experiences of the real-life implications of Judge Gorsuch's decision. I am honored to have these folks who have traveled all the way to Washington to tell their stories. Alphonse Madden of Detroit, Michigan, with his attorney, Bob Fetter. Say hello, Bob Fetter. Hi. Patricia Kaplinger of Springfield, Missouri. Is she here? Hiding over there in the corner. And the children of Professor Grace Wong, David and Catherine Wong of Manhattan, Kansas. A nice Manhattan, but not quite the one I know. I'll now turn it over to Senator Blumenthal.
Thank you. First, my thanks to Senator Schumer, not only as our leader, but also as a tireless advocate of American justice for everyday Americans. And that's why we're here today, with everyday Americans who sought justice in our court system and who have a story to tell about the consequences of injustice in everyday lives. And I want to thank them for their courage and their fortitude in coming today. Not easy to come to the Senate and stand up to a man who could be a United States Supreme Court justice. We're here today to discuss the concerns that Senator Schumer expressed so powerfully and eloquently, and I share them. In the days since I first met Judge Gorsuch, indeed at our first meeting, I have pressed him for answers on key, clear questions that he has an obligation to clarify. Workers' protection, consumer rights, women's health care, privacy rights, the independence of the judiciary. And so far, he has failed to be clear and forthcoming to any of us who have asked those questions. Beginning this Monday, he'll have another opportunity. And I will be pressing him and aggressively questioning him on all of these issues because he has an obligation to come clean with the American people before he assumes a lifetime appointment on the nation's highest court. And if he shows in his answers that he is out of the mainstream, as his opinions indicate that he may well be, I will use every tool available, including the filibuster, to oppose him. And I believe a number of my colleagues will as well. Now, he comes to us under highly unusual circumstances. Rarely, and perhaps never before, has a president of the United States established a litmus test for a Supreme Court nominee. And Donald Trump said repeatedly, indeed he promised during the campaign, that his nominee to the United States Supreme Court would be, quote, pro-life, end quote, very pro-Second Amendment, end quote, and of a conservative bent. His failure to be more forthcoming in his answers leaves an inescapable conclusion that he passes the Trump litmus test, which means he will not pass our test for a Supreme Court nominee. And there is another highly unusual circumstance. In fact, again, probably unique. Donald Trump essentially outsourced his pick and selection process. He outsourced it to the Heritage Foundation and to the Federalist Society. In fact, he took the unprecedented step of publicly announcing that he would be relying on these conservative partisan organizations to develop a list of potential Supreme Court nominees. Never before in American history has any president outsourced the selection of a Supreme Court nominee. But most concerningly to me are Judge Gorsuch's writings, opinions, dissents, as well as his articles, because they show a bias in favor of corporate interests against individual rights. And that is fundamentally against the grain of American justice. Our courts are meant to protect every individual against big institutions when the law is on their side. If the law can be twisted under the pretense of being a textualist or an originalist, it fails to stand for American justice. And those rights belong to every individual. The Supreme Court has a role to play, as does an independent judiciary. And if a nominee for the United States Supreme Court fails to stand strong for the independence of the judiciary and refuses to condemn attacks on the judiciary, that speaks volumes to me. And so far, Judge Gorsuch has failed to stand strong for the independence of the American judiciary. We've given him every opportunity to do so. We're going to give him another opportunity beginning Monday. I've immersed myself in his record and his written work, and we've got tough but respectful questions for him. And I believe that the American people deserve answers to those questions. The people who are here today are the face and voice of what happens when American justice goes off the tracks. And people should pay attention, because the United States Supreme Court is more than marble pillars and glazed portraits. It is the flesh and blood embodiment of American justice at the highest level, and these folks are the faces and voices of impacts of American justice. And so I'm very proud to be here today with them, and very proud to be here with Senator Schumer. And you'll now hear from our guests.
Thank you, Richard. As a former Supreme Court clerk and law review editor, this guy knows his legal stuff. I'd now like to call on Alphonse Madden to talk about his situation, case that he had from Detroit.
Thank you, Senator Schumer and Senator Blumenthal. Greetings, everyone. In January of 2009, I was working as a commercial truck driver for Trans Am Trucking Incorporated of Olathe, Kansas. I was hauling a load of meat through the state of Illinois. After stopping to resolve a discrepancy in the location to refuel, the brakes on the trailer froze. I contacted my employer, and they arranged for a repair unit to come to my location. I expected that help would arrive within an hour. I awoke 3 hours later to discover that I could not feel my feet. My skin was burning and cracking. My speech was slurred, and I was having trouble breathing. The temperature that night was roughly 27 degrees Fahrenheit below zero. The heater in the cabin was not producing heat, and the temperature gauge in the truck was reading minus 7 degrees below zero. After informing my employer of my physical condition, they responded by telling me to simply hang in there. As I sat there physically suffering in the cold, I started having thoughts that I was going to die. My physical condition was fading rapidly. I decided to try to detach the trailer from the truck and drive to safety. When I stepped out of the truck, I was concerned that I may fall because I was on the verge of passing out. I feared that if I fell, I would not have the strength to stand up and would die. I walked to the back of the trailer to place a lock on the cargo doors. The distance that I walked to the back of the trailer seemed like an eternity, as my feet absolutely had no feeling at all. I eventually was able to detach the tractor from the trailer. Before I left, I called my employer to notify them that I had decided to head for shelter, and they ordered me to either drag the trailer or stay put. In my opinion, clearly their cargo was more important than my life. My employer fired me for disobeying their orders. And I'd like to make it clear that although I detached the tractor from the trailer, I returned and I completed my job, and I was still fired. Okay. I disputed my termination from Trans Am Trucking and ultimately won. This was a 7-year battle. 7 different judges heard my case. One of those judges found against me. That judge was Neil Gorsuch. Fortunately, 2 other judges on the appeal panel decided in favor of my case, and ultimately I was victorious. In recent days, I have discovered that Judge Neil Gorsuch has been nominated for Supreme Court Justice by our nation's president. I have come to understand that because of his nomination, Judge Gorsuch's dissent in the case of Trans Am Trucking Incorporated versus Alphonse Madden has become a subject of scrutiny throughout the nation. Although the victorious outcome of this case was the culmination of a 7-year legal battle between myself and Trans Am Trucking, I wholeheartedly consider it a victory for the nation's workers. This is because at risk was the idea that an employer could legally force his employees to endure physical suffering and expose themselves to hazardous environments that are not suitable for sustaining human life. In light of Judge Gorsuch's Supreme Court nomination, many people have become interested in my opinion. First and foremost, please know that I am very thankful that our nation's judicial system ultimately rejected Trans Am Trucking's argument. Also, please know that I have great respect and admiration for Judge Gorsuch's accomplishments, the position that he holds, and the position that he has currently been nominated for. That withstanding, I was completely astonished upon discovering that my case was garnering so much attention as a result of Judge Gorsuch's Supreme Court nomination. Nonetheless, the notion that the only judge who issued a dissent relating to the matter of Alphonse Madden versus Trans Am Trucking has been nominated to become our nation's next Supreme Court justice gives me pause for concern. This is because after reviewing the wording of Judge Gorsuch's dissent concerning my case, it is my opinion that he demonstrated a willingness to artfully diminish the humane element that encompassed the issue and ignored the fact that the nation's Congress passed the Surface Transportation Assistance Act into law to uphold and maintain safe and humane working conditions. Considering the foregoing, I can only ask that people of this great nation, including the elected officials whose duty requires them to effect the nomination of this nation's next Supreme Court justice, consider the national ramifications on working people if the Supreme Court would have allowed Trans Am Trucking to prevail in this matter, as would have happened if Judge Gorsuch's ideology prevailed. Finally, please know that after enduring such a long legal battle, I am hopeful that its legacy bolstered our nation's integrity and further secured the safety of our nation's workers. On behalf of myself and the working people of this country, I appreciate your interest in this matter. Thank you.
Thanks, Alpha.
Ms. Kaplinger.
First, I would like to thank Senator Schumer and Blumenthal for having me here today and for the opportunity to speak before you. In August 2010, I underwent a posterior lumbar interbody fusion. Without my knowledge or consent, a product manufactured by Medtronic by the trade name of Infuse was placed in my back. Infuse was FDA approved only for use in an anterior through the abdomen surgical approach. Posterior placement constituted an off-label use. During my procedure, there was a Medtronic's representative in the operating room to provide product guidance to my neurosurgeon. Since my original surgery, I've undergone 4 revision surgeries in the space of less than 5 years to remove ectopic bone impinging on my nerve roots. I am in constant pain, and I'm no longer able to deploy with my disaster medical assistance team, nor am I able to work in the emergency room because it requires standing for 12-hour shifts. According to a study released in 2011 in the Journal of the American Medical Association, Infuse generates about $900 million in annual revenue for Medtronics. Yet after the original industry-sponsored trials, there were reports of problems by authors that were not sponsored by the manufacturer. With these reports, it was clear that this product was not safe. There were reports of bias which led to widespread, poorly considered on- and off-label use, eventually leading to life-threatening complications and death. There are reports in papers defending the product were paid for by Medtronics. After the publication of the Spine Journal article, Dr. Thomas Zablek, who wrote the Spine Journal, insisting that there were no attempts to hide the data in the reports.
Someone's it's a report. You never know these days what these things are.
Dr. Zablek received substantial payments in the form of royalties and other payments from Medtronics and was involved in the clinical trials of the product. He co-authored 2 papers on the product. The Wall Street Journal reported that 2 authors of studies purporting the safety of Infuse received millions of dollars from Medtronic. The paper reports that Dr. Zablek received $19 million between 2003 and 2007, and Dr. Burkus, another orthopedic surgeon, received $1.5 million. Dr. Burkus stated on several occasions that that the product had no adverse side effects. The Milwaukee Sentinel reported that Medtronics paid physicians $210 million in sham consulting fees and admittedly ghost wrote articles in professional journals touting the safety and efficacy of their product. The controversy over complications arising from this product was so intense that the Senate Finance Committee got involved. Senators Grassley and Baucus sent a letter to Medtronics expressing concern that the researchers in the Infuse clinical trials may have been aware of but did not report the harmful bone growth. In August 2011, Medtronic announced it would grant Yale University $2.5 million for an independent review of its product. In April of 2012, after I was injured, I filed suit against Medtronic for fraud and failure to warn about the problems related to its Infuse product. In February of 2013, Judge Miles LaGrange granted Medtronic's motion to dismiss. The case was appealed to the 10th Circuit Court of Appeals. Judge Neil Gorsuch held that even though Oklahoma law allows patients like me who are injured through a faulty medical device, my case could not even be heard by a jury. Even though the FDA at no time approved this device for the use that was implanted in me. His decision prevents me from recovering from Medtronic due to the injuries caused from their harmful products. Tens of thousands of people have been injured by this product. It is my belief that Judge Gorsuch rules in favor of big business. There are thousands of people like me who have been injured by this product. Judge Gorsuch failed to take into account the fraudulent methods utilized by Medtronic to promote this product, questionable payments to physicians to utilize the product, and the lack of admission of complications due to use of this product. Most importantly, he said, a patient like me, injured and in constant pain, through no fault of my own, could not hold those responsible accountable. Thank you.
Great job.
Okay, now we have the Wong family.
First off, I'd like to thank Senator Schumer and Blumenthal for inviting us here today and letting us share our story. My name is Catherine Huang, and this is my brother David. When I was 6 months old, my mother adopted me from China, a place where women are oppressed and taught to be obedient. However, growing up, I never knew that. Growing up, I saw an independent, single mother who always fought for what she believed in and never gave up. I saw a woman who worked tirelessly to give her 2 children everything they needed while never hesitating to help others. When I was in kindergarten, my mother was diagnosed with breast cancer. I didn't quite know what that meant. I just knew she was sick. My mother beat breast cancer and showed me from an early age what true strength looked like. When my mom was diagnosed with leukemia, I was just starting the 7th grade, so I understood the severity of her condition. During her treatment, you would never be able to tell that she was sick. She always had a smile on her face and never stopped in her dedication to helping others. This positive attitude is what helped my mom beat leukemia. My mother was incredibly passionate about her role as an educator. Since she was a single parent, I went to work with her frequently and saw firsthand her love of inspiring the next generation of leaders. One of the first things she asked about after returning home was when she could return to work. However, because of the flu epidemic on campus, her doctors advised her not to expose herself due to a compromised immune system. She was told that she had a week to show up or they would force her to resign or fire her. This decision to protect her health cost my mom her job. When Judge Gorsuch issued his ruling, he didn't think about the impact that this had on our family. Our only source of income was lost. We had to rely on loans from friends, disability, and jobs my brother and I had. With my mother's medical bills and our regular living expenses, we became financially burdened. The law calls for reasonable accommodation for those who are disabled. In his ruling, Judge Gorsuch said that showing up was an essential part of the job and that employers should not become a safety net for those who can't work. However, what my mom was requesting wasn't a safety net. It was extra time for her body to be healthy. She had shown up for 15 years and wasn't offered the opportunity to teach from home. This ruling was upsetting to me personally, not just because of my mother's case, but as a person with limited physical abilities. This ruling set the precedent that a company's needs come before those who are disabled. Such rulings are what weaken my faith in the justice system. I'm here today using the strength and courage that my mom showed me to make sure that she still has a voice and to make sure that her legacy is never forgotten. Thank you.
Very well done. Thank you. I might just, because she didn't mention it, just to tell you about Judge Gorsuch's ruling in Professor Wong's case. He ruled that the employer university's leave policy was, quote, more than sufficient because the law, quote, or the law should not, quote, turn employers into safety net providers for those who cannot work, end quote. His ruling was contrary to the Equal Employment Opportunity Commission guidance as to how employers should deal with cancer in the workplace, and with the Americans with Disabilities Act. His reasoning also was inconsistent with many other courts, including, for example, the First Circuit Court of Appeals, which ruled in favor of an employee who sought a 5-month extension for cancer treatment after the 1-year leave provided by her employer expired. Clearly, this ruling was an outlier.
I'd say these 3 rulings, and I want to thank our 3 people who testified, who give a human face to these rulings. But these rulings that Judge Gorsuch made would probably please Mr. Anschutz, please the Heritage Society, and maybe probably please the Federalist Society. They would not please the American people, should not please the Senate, no matter what someone's ideology is. We'll take questions. Yes, ma'am.
Well, let's begin with Judge Gorsuch's failure so far to respond to some of the concerns and questions raised by these kinds of cases, real-life stories about injustice that resulted from his opinions. We're going to be asking him about these cases and others, and we're going to be pressing him for answers to what his core beliefs are on privacy rights and an independent judiciary and women's health care and worker and consumer protection. Do Medtronic's rights always supersede individuals who are injured by a defective product? Do corporate rights prevail over individual citizens? And if we conclude that he's out of the mainstream and that his core beliefs are inconsistent with what American justice should be, we will use every tool at our disposal. We have procedural options within the committee. There are options on the floor of the Senate. And my hope is that our concerns will be shared across the aisle as well, because this selection of a Supreme Court justice and confirmation is one of the most important things we do as a congressional body. It is for a lifetime. It's the nation's highest court, and the American people deserve a court that has credibility and trust and should not be diminished if we conclude that Judge Gorsuch is out of the mainstream.
And I would just add one thing here. If Judge Gorsuch does what Judge Roberts then did and refuses to answer questions because it might jeopardize his rulings in future cases, I certainly and most of my colleagues will see that as not because he can legally certainly answer questions about existing cases and many other things. We will see it as a way of hiding his views from the American people, not simply sticking by some kind of judicial guideline. What many of these judges, nominees from the hard right, have done in the last decade is simply said, I'm not going to answer the question. And that is not required. In fact, it is required, in my judgment, for them to lay out their views before they take such a powerful position. Yes. Well, look, the bottom line is very simple. I think this is such an important position, you can't give somebody a pass. I don't intend to, and I think the vast majority of my colleagues don't intend to. As for the changing of the rules, which is, I think, what your question alludes to, I'd say 3 things. First, there are a good number of our Republican colleagues who don't want to change the rules. Second, we didn't change the rules for Supreme Court deliberately, because we knew it was such an important position, it ought to get some bipartisan support. And third, if a nominee cannot get 60 votes, you don't change the rules, you change the nominee. Look, I think many of my colleagues are skeptical but waiting for the hearings. I have touched base with a good number of my colleagues. After the hearings, I intend to make my views very strongly known to them. Each member will make his or her own decision. But I think there's a great deal of skepticism in the caucus about Judge Gorsuch based on his record, and I think the brave testimony of you four folks is going to further put questions in people's heads about whether Judge Gorsuch deserves to be on the United States Supreme Court, particularly at a time when America is crying out for help for average people, and that special corporate interests have the deck, and the deck is stacked against these people. That's what Donald Trump did when he ran, and then he nominates somebody like Judge Gorsuch. It's a total contradiction, given what we've heard today. Yes, sir. I have a strong presumption against. I'll wait till the hearing. If he says some dramatic things that might reverse everything that I've read and heard, and his refusal to answer the simplest of questions in his meeting with me, such as if there were a law that said all Muslims should be banned from entering the United States, would that be unconstitutional? He even refused to answer that kind of simple question that someone in the second week of law school could answer. So I have a strong presumption against, and the hearing would have to turn a lot of those presumptions around for me to change my mind, but I'm waiting for the hearing to make a final decision.
And if I could just add, I think that the high burden of proof, the exacting standard that Judge Gorsuch has to meet, largely is a result of the president who nominated him in establishing a litmus test and outsourcing the selection to far-right conservative groups. And the other reason it's the doing of the president is there has never been an administration so rife with conflicts of interest. And so some of the questions are going to be about whether Judge Gorsuch believes that members of the Supreme Court should comply with a standard for conflicts of interest. Thus far, the court has said that it should not be subject to the law that other judges throughout the federal system have to comply with. And so this is a very unique nominee because of the administration who has put his name forward.
This will be the last question.
Some Republicans are uncomfortable with the idea of changing the rules. What do you base that on? Have you spoken to anybody? Have you just read sort of previous comments? Or where are you getting that?
Based it on a whole lot of things. Thank you, everybody.